Hi, Kim, are you there? Come back on early. Also, I fall. Hi, Kim, are you there?
Yes, I am.
All right, I'm going to grab Judge Armada.
Okay, thanks.
Mhm. All right, Kim, we're ready to add the FTR.
It's all set. I just put it in.
Okay, thank you.
Yep.
Good afternoon, everybody. Can everybody hear me?
Yes.
Yes.
Okay, so the court's going to take up the matter of Perry versus Riley, docket number FA20-501-3724. If the parties could be placed under oath and counsel could identify, then we'll go on.
Can I have both parties raise their right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I sure do.
Ma'am, can you please state your full name and your address for the record?
Priscilla Allen Perry, 101 South Street, apartment 34, Vernon, Connecticut, 06066.
Thank you. And sir?
Tim Riley, 46 Oakwood Lane, Columbia, Connecticut, 06237.
There's
Thank
Matthew
you.
Potter on behalf of the plaintiff.
And Attorney Monique Ryan with the Children's Law Center.
And Paul Lorenzo, Family Services, 428 Hartford Turnpike.
All right. Before we begin, because this is a virtual hearing, if anybody has any problems with connectivity, can't hear, please bring it to the court's attention. the court clerk is monitoring the situation, and we want to make sure everybody can be heard or hear what is going on. Second, I want to remind everybody that in accordance with judicial policy, there is to be no recording or taping of these proceedings. Third, other than Attorney Potter and Ms. Perry, is there anybody present in the room with you, Attorney Ryan?
No, sir.
And Mr. Riley, is there anybody present in the room with you, sir?
No.
Okay, thank you. So I want to go over sort of the history and explain what we're here for and where we are. So this case started on May 11, 2020 with a custody application wherein Priscilla Riley is the applicant and Priscilla Perry is the applicant and Timothy Riley is the respondent. The child at issue is Araya. Am I saying that right, folks?
Yes, that is correct, sir.
Okay, an 11-year-old child. In that application, the applicant alleges that Connecticut is the home state, and she seeks sole legal custody, primary residence, child support, and educational support order. On that same day, the applicant, Ms. Perry, also filed an ex parte motion of custody, number 101. In that motion, the applicant alleges that the child's always lived with her, the father's never paid child support, had gotten no prior orders because she couldn't financially afford the same, and was at risk of losing her job. She alleges that the respondent threatened her and was mentally and verbally harassing and abusive. She indicated she had a year-long restraining order that ended in December of 2019, that things between the parties were cooperative and that they were co-parenting. But then she alleges the respondent became emotionally and verbally abusive, and she was afraid he was doing the same to the party's daughter. She indicated he refused to return the child since that she thought that was a threat to the child's educational distance learning, and she felt her daughter was not safe. She indicated that Mr. Riley is denying the child a proper education. She also indicated he could not provide for her, and that she didn't have clothes, shared a bed with her 5-year-old brother. She alleged that she worried for her safety, mental health due to his behavior, abusive behavior. And based on that, the court granted the application, giving the applicant temporary custody until a hearing set for May 2nd, 2020 in Hartford, and that neither party, the court also ordered that neither party interfere with the educational program of the child nor remove the child from the state of Connecticut. The court will note that service of that application for custody and the motion was made on the respondent on May 11th by in-hand service by State Marshal Gregory Woodruff. On May 20th, 2020, Judge Maczarowski, sitting in the Hartford court after hearing evidence on the matter, denied the ex parte motion. On May 22nd, Ms. Perry again filed an ex parte motion for custody, number 106. In that application, the applicant alleged that the respondent, Mr. Riley, refuses to return the child. She indicated the child was suffering from psychological harm and that she's been the primary parent since birth. She indicated the child needed food, was at risk of physical harm and neglect. She alleges past physical abuse by Mr. Riley and that he is manipulating the child so as to have her make false statements that the child was abused while in the mother's care and was gaslighting. She alleges control by the father, that he is non-cooperative with the state police in terms of prior court orders, and he continues to deny the mother access to the child. The matter was reviewed by the court and was denied by Judge Carasquello out of the Hartford Family Court, as Rockville Family Court was closed at that time. On May 22nd, 2020, the mother also filed a motion for modification number 108, indicating that the respondent had denied her access to her daughter and the mother sought sole legal custody. On June 25th, 2020, the applicant again filed a motion for pendente lite contempt, or filed a motion, this time for pendente lite contempt, claiming the father was violating the automatic order served with the custody application, which required that the child see the other parent consistent with the habits of the family. On July 22nd, 2020, the applicant requested an immediate hearing, claiming the respondent had refused to let the plaintiff have any reasonable access to the child for months. On August 28th, the following orders entered. According to the court record, with all counsel present and all parties present, Judge Maczarowski, based on the evidence before the court, including, and I'm reading from the court order, the testimony of both parties and documents submitted, the court finds that the defendant has